Welcome to the Startup to Exit podcast, where we will bring you world-class entrepreneurs and VCs to share their hard-earned success stories and secrets. This podcast has been brought to you by TIE Seattle. TIE is a global nonprofit that focuses on fostering entrepreneurship. TIE Seattle offers a range of programs, including the Go Vertical Startup Creation Weekend, TIE Entrepreneur Institute, and the TIE Seattle Angel Network. We encourage you to become a TIE member so you can gain access to these great programs. To become a member, please visit www.seattle.tie.org.
Hello, everybody. Welcome to another episode of From Startup to Exit. My name is Gauri Shankar. I'm on the board of TIE Seattle, and this podcast is brought to you by TIE Seattle. It's been great fun hosting this along with my fellow TIE Seattle board member, Shirish Natkarni. And we've been doing this for a year. So thank you all for your support and spreading the word. And I'm hoping that you all enjoy the content that we are bringing you from all the guests we've had. Shirish is a serial entrepreneur based in Seattle also, but now he's a serial author. His latest book, Winner Takes All, is available wherever books are sold. His first book, From Startup to Exit, from which we borrowed the title of this podcast, has been out for a few years. It's a fantastic book and a must-read for all entrepreneurs. This is another great episode, a fantastic guest we have. I'll have Shirish introduce the guest and take it away.
Thank you, Gauri. Today's podcast is about Gen AI and the legal implications of building a model. Very pleased to welcome Adam Shevell, who's a partner in Wilson Sonsini's San Francisco office. He had worked earlier in Seattle as well. He now co-leads the firm's technology transactions practice in the city. Adam advises technology companies and their investors at all stages of company development, from early stage startups to leading global enterprises, as well as angel investors, VCs, and other institutions in the startup ecosystem. So welcome, Adam.
Thank you. I appreciate the opportunity to talk with you both, and I look forward to it.
Excellent. So let's start with your background. Can you tell us a little bit more about your background and how you got to develop AI ML expertise from a legal perspective, and what kind of AI ML work are you currently doing?
Sure, I'd be happy to. I've been an attorney for 17 years now, and for most of that time, I have focused on technology and intellectual property rights, primarily as they pertain to technology companies, startups, and larger enterprises in the global economy. And as an IP attorney, my job is to understand the rules of the road for intellectual property rights in the United States, in other countries as well, and to understand how those apply to the technologies that our clients are building, commercializing, exploiting, and protecting, right? And that applies to any type of startup. It could be a mobile app, it could be an enterprise SaaS product, or it could be a large language model, right? And so what's interesting is, one thing I like about the job is that I constantly have to learn about new technologies, right? As technologies develop, it's incumbent on me to do my job well, to understand the new things that are coming out, right? And in many ways, artificial intelligence and machine learning is no different, right? There have been lots of different waves of new technology that come out during my career, and each time, myself and my colleagues have to understand and learn and get our sort of our hands dirty with understanding what it is, and then figuring out what intellectual property right issues apply, both generically as they might be developing the technology, or as they get into the market and start doing business deals with other companies. How do the specific IP rights pertaining to that technology impact the ways you should or should not do deals in the market? Now, what was a little different with AI and machine learning, and specifically generative AI is there are two things I would point out. One is the questions of law were so new in a way that we haven't seen in a while, right? It really was a groundbreaking type of questions that are so new that no one really had an idea of how the courts will answer those questions as they pertain to Gen AI. And we're still waiting for the courts to answer a lot of these questions, right? The other factor I'd point out is just the speed with which it was adopted and deployed. ChatGPT was released in November of 2022, and by the spring of 2023, it was hard keeping up with the news as far as types of news stories, new companies, new applications, news about ChatGPT and other challengers. It was almost dizzying, the velocity of news that was coming out. And so the rapidity with which generative AI was adopted, not just by the tech industry, but then by all people of all walks of life using ChatGPT and Claude and other generative AI products, was really amazing. And so it was both the speed and the novelty of the issues that gave us an even greater challenge. But as far as professional sort of observations, it really was the perfect storm for myself and my colleagues who do this kind of work to be right in the place where intellectual property rights were so relevant to this new technology in a way that made our jobs even more relevant and our advice even more relevant to companies who are building and using tools in this space.
Great, thanks for the introduction. As you rightly mentioned, there's been a dramatic interest in LLMs, starting with OpenAI, but there are many other companies like Anthropic and Facebook and Google and others who have built large language models. And it's rumored that the way that they trained these models was by scraping content from the web. I mean, certainly Google had its own content and Facebook has its own content, but OpenAI clearly does not have its own content. Can you talk about the various legal perspectives on how legal it is that what they've done?
Sure. And I'll say the legal questions around scraping content from the internet are not new, because the internet's been around for almost 30 years now, and we have precedents and we have a track record that we can point to as far as the types of claims plaintiffs have made in the past, alleging wrongdoing or alleging foul play with companies or individuals who have copied content from their website, otherwise called. So the first and obvious one is copyright infringement, right? And we can get to that in a second. The second is people would argue, or content owners would argue, that there's a breach of contract. If someone comes onto their website, they've agreed to the terms of service on that website, and most terms of service advise or require that the visitors do not copy content without authorization, right? And so there's an argument that scraping content on a website is a breach of contract of those terms of service that apply to that website. Another claim that's been made is trespass to chattel, and that's an old way of saying you've interfered in my property, right? You've come onto my property and done damage, and typically this is used when, let's say, your access and scraping of a site diminishes its ability to operate well, right? Maybe it's loading slowly, it's having a lot of errors because you're overloading the website because of the amount of scraping you're doing of the website that you access. In those cases, you might see a trespass to chattel claim as well. Another claim that's been thrown around is unfair competition. And so this is as straightforward as it sounds. I've spent and invested money, I've invested resources in compiling and generating and creating the content that I own on my website. You can't just come along, grab it, and piggyback and free ride on my efforts, that's unfair. Okay. The last would be the Computer Fraud and Abuse Act. This is a statute that it prohibits actors from accessing other people's computer systems without authority and essentially doing bad things, for lack of better words, right? And so this would be a classic thing. If someone's hacking another person's computer, that could be a violation of the Computer Fraud and Abuse Act, the CFAA. And there are ways in which plaintiffs will argue that if you're scraping without authorization, you're illegally accessing my computer server, and therefore you're in violation of the CFAA. So those are the types of claims that get thrown at companies who are scraping content from the internet. And I want to go back to copyright infringement, because that's going to be the biggest one here, and probably the one we discuss the most today. So the Copyright Act gives owners of works of authorship, right? That could be a photo, that can be written language, that can be all sorts of videos. The copyright owner gets, under the Act, the exclusive right to control certain things with regard to that work of authorship, right? They exclusively control the right to reproduce that work of authorship, the distribution. They have the exclusive right to prepare derivative works of that work of authorship. They have the exclusive right to publicly display or perform the work. So, in other words, the copyright owner controls who gets to do these things with their work. Obviously, if someone is coming in and copy pasting the works from the internet, there's a reproduction happening, right? There could be a distribution happening there. If they take that later and make derivative works, that's another exclusive right. And so on the one side, people argue that scraping violates the copyright owner's exclusive rights unless they have authorization from them, right? And that's sort of the basis of how our statute around copyright works, is that we give the author exclusive control over these things, and unless you have those rights, unless you have permission from the copyright owner, you're prohibited under the Act to do those things.
So let's talk a little bit about the Copyright Act. So search engines today go across the web. They check the robots.txt file to see if they have permission. They download the entire content of the page, and they can even produce a snippet of that page in the search results. So why are they not in copyright infringement in that case, even though they've technically been given permission through the robots.txt file?
Sure. And so I'm glad you raised that, because the counterpart to the exclusive rights of the copyright owner is the fair use rights of others to use copyright. And I think what you just touched on comes down to fair use. So what fair use is it's an exception to the exclusive rights of the copyright owner. So that Section 107 of the Copyright Act says, even though a copyright owner has exclusive rights over their work of authorship, individuals can do all the exercise those exclusive rights if they meet a certain criteria that constitutes fair use. And there are 4 primary criteria listed as the considerations the court will look at to determine whether or not a certain use is fair use. The first is the purpose and character of use. This is often the one that's most heavily weighted in the calculation, right? And here we look at whether or not are they using the copyrighted work in the same manner for the same thing, or are they using it for something completely different? And the word you'll hear used in this regard is it a transformative use, right? Are they taking something and making it and using it in an entirely different and novel way, such that the work's use is transformed, right? The second factor is the nature of the copyrighted work. the more creativity in the work, the more protection it gets under this doctrine, and the less creative the work. So think of, let's say, an instruction manual for your washing machine is going to it's easier to use that as fair use than a work of art in the museum, right? So that speaks to the nature of the copyrighted work. The third question is, how much of the work did you use, right? If you use a small snippet of the totality of the work of authorship, it's more likely to be deemed fair use than if you use, let's say, the entire thing. Because again, we're trying to get at what is the dividing line between respecting the rights of the copyright owner who's invested their time and energy to produce this versus others who may want to repurpose the work for other purposes. And then lastly, the fourth factor is the effect on the copyrighted works market, right? So where the sort of the use of the work of authorship competes directly with the original copyright owner's use of the work, it'll be less likely to be fair use, right? Where you're using a copyrighted work in a manner that does not impact the market for the original work, that is more likely to be fair use. And the challenge with fair use and the trickiness of advising companies on whether or not they can take a fair use approach is you can't pre-clear something as fair use, right? Each specific use case is going to be looked at uniquely by the court. So there's no way we can say ahead of time, this is fair use and this is not fair use. We can advise this is more likely and this is less likely, but until you go to court and have a judge look at these factors and weigh them and come to a conclusion as a matter of law, you just don't know if what you're doing is fair use. But you can get a sense once you have these factors looked at as to whether there are ways you can do it that are more likely to be fair use or less likely to be fair use, right? And that's a big challenge for companies because and uncertainty is challenging, and companies are investing obviously a lot of money into developing large language models, into developing other forms of AI, whether it's generative AI or not, and not having answers to whether or not their conduct with respect to data and content is permitted or not is a big question mark hanging over the entire endeavor, right? Just for instance, traditionally I mentioned the question of whether or not use is transformative was always typically the most important factor in this recipe for fair use. But then recently, the Supreme Court ruled, I believe it was in 2023, that it was a case regarding an Andy Warhol painting, right? And the Andy Warhol painting was admittedly a derivative work of a photographer's photo of Prince, the artist, the recording artist. And so the Warhol print was sold to a magazine that was writing a story about Prince and ran in the magazine. And the court said, putting aside the question of his creation of the work of art, the fact of licensing the Andy Warhol print of this photo to the magazine was in direct competition with the original photographer, whose business was to take photographs and license them to magazines. And so it elevated this last factor, which is the effect on the copyright works market, right? They said that was not fair use because the way you were using this work of art by Andy Warhol directly interfered in the market for the original photograph, which could have been used instead by the magazine, but instead they purchased a license to use the print from Andy Warhol instead of the photograph from the original photographer. The other thing I'd point out to companies out there thinking about this is that unfortunately the court systems aren't you know, they don't move very quickly, right? There's no move fast and break things. It's the opposite. Move slow and make sure nothing breaks, right? And that's part of the strength of the judiciary and the law, is that it's conservative and moves slowly so that people have predictability and continuity with the past. But these questions are very important. They're very pertinent to companies who are developing LLMs and other kinds of AI technologies now. And it's unlikely we're going to get good answers or clear answers for many years. And so it's going to be interesting once these cases start landing with judgments, because we're going to have many years of development at very high pace to retroactively look at and apply and figure out whether or not this type of technology might be in peril because of the legal rulings, while that type of technology is not, right? Mm-hmm. And just to give an example, the last sort of very large fair use case that went to the Supreme Court was Oracle versus Google, Oracle v. Google. And that lawsuit took almost 11 years from first filing to Supreme Court ruling to get a clear ruling, right? And so that's an eternity in this environment, and it's hard to see how the sort of the legal process is going to keep up with the demands of the innovation cycle and how fast this technology is coming to market.
Great. So as we know, large language models today have scraped all kind of content, including literary works, poems, etc. But when they produce content, they're not regurgitating the same content. It is there have been some instances where they have been tricked into doing that, but in vast majority of the cases, they create new content that's based on what they have learned. So can you not argue that it's under the fair use doctrine that it is transformative content, and so should be okay with the fair use doctrine?
I mean, that's the billion-dollar question here, right? It is the technology's use of the content transformative or not, right? And depending on which side of the issue you sit on, I think you'll find people with opposite views, right? The developers of LLMs claim that, hey, we might be copying without authorization, but we're putting it to a use that is completely transformative, right? We're training the weights and biases of these models, and then those models are going to go out and create something entirely new that is a unpredictable creation based on the totality of all the content that it has been trained on, right? And I have sympathy for that argument. On the other side, you have content owners saying, "Hey, yes, that's theoretically that's true, but also with the right prompting, you can produce word for word the songs that were ingested by your LLM, or produce photographs with our watermark on them." And both those cases are actually going through courts right now, and I have some sympathy for those too. It's it really is it's not a home run here, right? And it's going to be very interesting, and it may come down to specific judges, specific courts, specific fact patterns. There's a saying in law, bad facts create bad judgments and bad rulings, bad case law. So it really is going to depend on who's getting a judgment from where first, and who's deciding on them.
Great. All right, over to you, Gauri, to continue the conversation.
Yeah, this is quite fascinating, right? So the players today, right, the LLM players, although they're all in some fashion startups, but they all have deep-pocketed investors or partners, right? So they have the ability to maybe sustain the lengthy, methodical judiciary, approach. But if you're a startup, right, and taking it down, you're looking at the stack and trying to figure out, is there value that can be created? in a fashion that solves a very specific problem across the world. How do then startups sort of think about this? Because as it is, they're giving up a lot of money to starting with NVIDIA to LLM player, right? So suddenly now you got to set aside a large legal escrow, for lack of a better word, to figure out if you are within the domain, and they may not even be in it. It's all sort of fleeting. So how, as a lawyer, would you advise startups to approach this problem? Because that's the most funded category at the moment from a VC perspective.
Yeah, absolutely. I think the most important thing for startups is to become educated about all the different issues and understand what we know and don't know, right? Where are the uncertainties and where do we have better certainty, right? And you need to be pragmatic and understand, are there ways we can de-risk certain facets of our product or not, right? For instance, and this is maybe not completely right on target, but you can use ChatGPT on a free basis, and ChatGPT and OpenAI will then take your inputs and retrain the model with your inputs. Or you can use ChatGPT on an enterprise basis. You pay a monthly subscription, and OpenAI will not take your inputs and train the model with them. And that's one very easy way to de-risk your use of generative AI, right? For companies who are building on the generative AI stack, you just want to get your arms around these legal questions, right? The question of scraping and copyright infringement. If you're building on top of the LLMs, mostly that's an issue for your providers, right? That's like Anthropic, OpenAI, Meta. The companies who are doing that ingestion are really facing the risk. You, as the downstream user, preparing a product that is powered by those LLMs, you have different considerations, right? What you don't want to do is produce content that infringes the content owners originally. You're not so concerned about the scraping, copying, and training process, right? And so downstream, you might think about, okay, what kind of guardrails can we put in place, right? Do we scan and screen output before it's made available or not? How do we do that, right? So, you want to understand where you're situated. Where's your product situated within the stack? And then what are the issues that are most exposing us most to risk, and where are the things that are not of a concern, right? And then, some of this can be mitigated through contracts, right? Like, I'll take an example. You can, let's say, if you have a direct to consumer product and your consumers have to agree to terms of service, there's a lot of risk you can mitigate there through smart contracting with your consumers, right? One issue that companies need to understand around generative AI, if they don't already, is that the output from a computer, like the model generates the output and the content. There's no copyright protection on that content. And also, companies aren't able to patent the output of generative AI. And so, because of that, your rights and ability to protect that content is diminished. So, knowing that, how do you mitigate certain issues in your business? For instance, if you're hiring a developer to build part of your software stack, you might consider requiring them not to use generative AI products in the software they're developing, because you don't want them to deliver a bunch of software that has no copyright on it, if you're worried about protecting it. On the other hand, maybe you don't care if there's copyright on the software because you're just going to use it on the server side. No one's ever going to look at it or have access to it. And so, hey, if they can make the developer more efficient by using Copilot to write, great. We save money, they save money, perfect. So it's just being aware of the issues, where the risks and pitfalls lie, and then understanding how they line up with your business and strategy, and making sure you're not accidentally walking into a big gaping pit of risk.
Right. Startups in general usually wake up and think, hey, how do I solve problem? How do I acquire more customers, increase revenues, increase valuation? Right. They don't wake up thinking the legal ramifications, if any there are, to even put guardrails around their fast-moving train, right? Because it's a usually an arms race, and they're trying to do that, right? But this is a unique situation because um, there's a lot of court cases going through the courts with generative AI, and especially if you're focusing on enterprises, the enterprises may share data that has never been exposed at all because it's closed. Nobody could have got to it, and therefore now you're using it to model it. And the minute you mingle and create this model to solve a problem in any fashion, it exposes, or it could expose you to uh, to the legal, challenges, if any there are. So the tricky part for a startup is, how do I balance these two things? Because it's not about just the money; it's about building a deliberate culture or DNA to pause. And you've been around startups for a long time. Pausing is not a feature of any startup. They just pound it. So how would you, if you were advising us, say Shirish and I as founders, what would you say we got to be cognizant of on a regular basis as we just barrel down the road?
Yeah. Great. First of all, I'd love to advise you guys if you're working together. That would be. And what I say is, it there are certain points of strategy, MVP, build, iteration, where you're laying out a new roadmap,
Yeah.
and it's worthwhile just to sit down, even if it's a 10-minute chat with your IP lawyer.
Mhm.
You don't need a whole team. You don't need a full week of meetings, but just update them and say, hey, here's what we're doing. Any concerns? What would you flag? What are your biggest concerns? And just start to be in the process of just bringing them in to into the tent, as they say, for a brief. Just let them see what's happening, because they'll be able to raise the flag if there is anything, or they might point in a certain direction, say, hey, you know what? Look, you're leaving these chips on the table, or you're exposing yourself unnecessarily to risk by doing these things. Just close that door, and the wind will stop blowing through it, right? Like just those little things that sometimes, because this is what we do day in, day out, we're really adept at seeing those pitfalls and risks that a founder who has much more important issues to think about most of the time isn't focused on, and they shouldn't be focused on them most of the time. Sometimes it's important to really, I say, roll up your sleeves and work and do a deep dive on this if it's like required, and if it's going to really bring business value to the company, right? Like all this has to be dialed in with what's valuable for the company. And sometimes what's valuable for the company in the moment is taking on risk and worrying about it later, as long as that's a eyes wide open decision by the company to do that and the founder to do that. There's nothing wrong with that. But running into risk without knowing it is the thing we're trying to avoid here. And having check-ins very informally, just to let your IP attorney know what's happening, can help you keep your eyes wide open and not miss those pitfalls.
Got it. Yeah. So that I think that's a great takeaway, Adam, is startup founders have never, they've consulted lawyers only for absolute regulatory or compliance. Now they got to sort of be cognizant of, hey, what am I doing here? This is building a guardrail around your product. That's a new reality that probably a lot of them will learn. And hopefully the investors class will also give them a lot of support doing that. And part of it is, say, for example, New York Times was v. OpenAI, right? Or GitHub being sued by open source developers, right? Do these cases point to anything, or are they more about establishing rights around their own content? Who is it going to benefit, and how do we all read from these cases?
Yeah, sure. Great question. Um, what you see is the battle between content owners and LLM developers, right?
Mm-hmm.
And it's expected.
Mm-hmm.
It's hard to tell what the outcome is going to be in any one case,
Mm-hmm.
other than we're hoping to get some rulings so that we can start telling our clients pragmatically,
Mm-hmm.
here's what such and such court held, and here's what you can take from that. Currently, we don't really have that yet, right? So we can't even give direction. We're waiting for that. I think what we're already seeing, and it's no surprise, companies being more proactive, content owners being proactive about licensing deals, and interestingly, seeing the larger LLM developers agreeing to deals, right, paying for content, paying for large license deals, and having companies, the content owners, realize that they're sitting on some gold here, and that they can do something with it, right? And in some ways, I suspect a lot of the lawsuits are positioning for a settlement type license deal, right, out of it.
Right.
Now, obviously, the open source software developers who are suing GitHub aren't looking for a big payment, right? They literally made their software available for free.
Yeah.
So it's not about a license. There, it seems more about the principle.
Yeah.
Right.
Yeah.
And as a reminder, in open source software, it's free as in free speech, not free as in free beer. They say, right? You're allowed to use it, but there are requirements, even if it's no cost to the user. Right.
Yeah.
So typically, an open source software license will require at least that the user gives attribution to the copyright owner.
Yeah.
It says, copyright so and so 2024. Used a license, and we just warranties. And sometimes there are even stricter requirements, like under GPL, and others. But the argument in this case is when GitHub copied and trained its model for Copilot, it essentially it didn't use didn't fill the notification requirements of the open source software license. So it's a breach of contract, right? You need to tell your users downstream that the code that's coming out of Copilot is copyright open source developer, right? And to the extent the Copilot reproduces the original open source software work very closely, you could argue that they've really failed to give copyright notice and notice of the original license, right? So that's the basis of the dispute. In that case, it doesn't seem like a shakedown for a licensing fee. It really does feel like something under a principled approach to this real question of law that hasn't been answered yet.
Yeah. I mean, open source community in general is okay with you using the software. I think the undue benefit that is perceived that GitHub might have gotten by using their software without the backup, without the reciprocal exchange of benefit back to the open source, seems like the principle of it. Hey, I'm contributing with good faith that you will also contribute so that the community gets better. In this case, unclear for the open source community, what is it they're getting back, even if it was trained to use a model. I think that seems like the crux of the issue. The other thing is, as these cases go down the court system and rulings, settlements, all of these happen, the truth is that all the content that's available has been used to train. I mean, there's no more, the creation of content isn't keeping pace with the training model. Just compute power is much more powerful, right? So now the next bastion is not to publish content. It's sort of the inside the wall of companies or your cameras or your old VCR tapes, etc. Right? So now the question comes down to, as a startup, I'm getting something new, I'm making something with it, giving it back to those that gave it to me. The exchange there could be fair, but suddenly I could also be exposing uh, the data to others unwittingly, just the way the workflow works. So you may have to kind of get there. That becomes a tricky one because it's not something that startups are adept at handling, because every time they use an LLM or a model, they have to figure out, hey, what am I give and get? This is sort of where the open source GitHub, I'm sort of jumping off of that, saying if you are a startup or an open source developer, the problems could be similar. How do startups manage this, especially with enterprise data?
Yeah, I think so. The situation is startups should do their best to understand, again, the risks and pitfalls, right? And like for instance, they're early after ChatGPT was released, a team of software engineers at Samsung were using ChatGPT to debug their software, and they uploaded to the input prompt box a bunch of confidential software, right? Not realizing that it was going to be trained, the software is going to be used to train ChatGPT. And a lot of them lost their jobs after the fact, after it was discovered, right? And they didn't realize that. Had they known that, they wouldn't have done it, right? And again, it points to the knowledge is king here, right? So for startups, really understanding the ecosystem and how the different exposure points are. If you're in possession of enterprise data, what does protecting that enterprise data in 2024 mean? Different than it would have meant in before 2022, right? And how, like, are there additional protections and sort of industry practices needed to keep your promise with respect to how you're going to protect enterprise data from your potentially expose it to scraping and other issues.
Got it. Excellent. Adam, we could talk for a long, long time. What's interesting about this conversation is startups don't think about lawyers or even connecting with them other than for some regular reasons. But now the way you presented today helps startup to think about how to collaborate, because they are, like, you have a finance person, you have an accounting person. As startups become focused on the Gen AI, legal should be sort of coming further upstream, as opposed to usually the afterthoughts. Hey, I need a contract, or I need this one. The core of what you're building has some legal implications, and the way you helped clarify that, I think, would be very useful for our audience. Thanks for doing that. I really, really appreciate it. Shirish, back to you.
Great. Yeah, again, a fascinating discussion. Adam, on that note, how can startups get a hold of you?
Yeah, best would be either by email. I'm at ashevell@wsgr.com. So ASHEV as in Victor, ELL at WSGR.com, or on LinkedIn. You can find me there, Adam Shevell. Happy to chat with anyone who has these questions. And again, Gowri, your suggestion is one that speaks to my heart's content of bringing your lawyer in. It doesn't have to be a big job. It doesn't have to be an expensive amount of time. Just short little check-ins to really be sure that you have alignment. If you're building LLMs, if you're building in this space, there are so many legal pitfalls. It would be great to have that sort of product advice, that product roadmap vetted by your lawyer as you go along, so that you don't have to redo a lot of your work later when you get to, let's say, a big investment round and your investors have concerns about the legality of what you've done.
Excellent. Yep. Appreciate it.
All right. Thank you, Adam. Wonderful talking to you. And we will also share, I think the paper that you shared with me is also very instructive. We'll put that in the notes for the podcast.
That's great. Thanks for having me.
Thank you, Adam.
Thank you.
Thank you for listening to our podcast From Startup to Exit, brought to you by TIE Seattle. Assisting in production today are Isha Jain and Mini Verma. Please subscribe to our podcast and rate our podcast wherever you listen to them. Hope you enjoyed it.